in what circumstances or under what circumstances are you willing to write a blank check, right? Because defense and indemnity can essentially be a blank check.
When we get a list of potential arbitrators for a particular matter, we know that these are either lawyers who practice construction law, they understand projects, they understand the scopes of work, or sometimes they're engineers who are retired or contractors who are retired, and they want to take on this role as being a decision maker and help in these disputes. Hello, everyone. This is Chip Bachara with Bachara Construction Law Group, and with me today is Hugh Higgins. Hugh is the managing partner of our St. Petersburg office, and today Hugh and I are going to continue our conversation about construction contracts, and we're going to address today in particular dispute resolution, arbitration versus litigation, and recovery of attorney's fees with regard to overall dispute resolution. We use that term dispute resolution as lawyers. What it really means is, how are you going to resolve a dispute between the parties? How is it, are we going to settle this? Are we going to court? Are we going to arbitration or some other format that we put in place? And what you will typically see in construction contracts is that the parties will agree that they will go to arbitration, or if there's no agreement to go to arbitration, then it will go to litigation in the court system. And let's talk a little bit about those distinctions, because those are the two most common. You're going to have arbitration and litigation. And of course, maybe in both of those situations, what we see very commonly now in construction contracts is that there is a step that has to be taken ahead of time, and that is to go to mediation. And it's what they refer to as pre-suit mediation. I know you and I both had a number of those. Tell me what your view on pre-suit mediation and the success of those.
Lawyer answer, it depends.
Right, yeah.
Pre-suit mediation is great when you have parties that really want to resolve the issue and parties that appreciate the expense and the risk of litigation or arbitration. But even when a pre-suit mediation doesn't settle a case, I still think it's a useful tool, because without sending out a whole bunch of written discovery, without taking a bunch of depositions, you get everybody together with a neutral and you talk about the issues as you know them and the disagreements as you know them, and you see if you can find some common grounds. And then you also see how far apart are we, right? I mean, before you go and spend a bunch of money on legal fees, what's the gap? It can be a useful assessment tool, as well as, with the right counsel, with the right mediator involved, you can begin the consensus making process.
That's a good approach and a good attitude to have for that. My experience has been that early on in the dispute process, the parties are dug in. They know that they're right. They know the other side's wrong, and they know their lawyer is going to win the case for them. And they don't want to show a lot of their hand. They don't want to really tell the other side too much of it. They may tell the mediator some information, but they're still going to play it very close to the vest, and so you don't get as much information forthcoming. However, I think what you may be experiencing is a contractor or an owner or a subcontractor that has been through the pain of litigation, and they understand how much litigation costs and why it's important to settle them early. They may come into it with a better attitude, with more of a desire to resolve the dispute early than someone who hasn't been through the process before. And so that is where it can pay off. But then once you get past that, then you've got a choice, but you've got to make this choice ahead of time when you're preparing the contract. Do you want to have arbitration as an option versus litigation? Tell me, what are your thoughts on arbitration versus litigation?
The benefits of arbitration, there are a lot. One of the biggest is it's completely private. And for some clients, the ability to have a completely private forum, something that's not in the public record, it's not going to be blasted all over the press, that could be a huge benefit. Also, the the discovery can be much more streamlined in the arbitration process, depending on the types of rules that you've agreed to in the contract. So if you're a party that may frequently have claims and you want to have a predictable method for resolving those claims that has, streamlined discovery, a way of getting to a resolution point sooner, then arbitration is likely going to be a really good choice because it has those benefits.
Yeah.
On the flip side, some people prefer litigation either just because they're not as comfortable with the arbitration process. They've litigated more, so that's the comfy ground. And the judges in the court system have more power to make parties and non-parties do certain things. I've found that the arbitration tribunal is somewhat limited in compelling a party or non-party to give over certain sensitive documents that they may be withholding than, say, a court.
And another one of the advantages to arbitration, and especially for contractors and trade contractors, is that you typically have a judge, a trier of fact, an arbitrator, or a panel of arbitrators. We'll talk a little bit about that is knowledgeable about the industry. We typically, when we get a list of potential arbitrators for a particular matter, we know that these are either lawyers who practice construction law, they understand projects, they understand the scopes of work, or sometimes they're engineers who are retired or contractors who are retired, and they want to take on this role as being a decision maker and help in these disputes. And so I think that's yet another one of the big advantages to arbitration. Discovery is limited in arbitration to whatever the attorneys or the parties want to limit it to. And that's one of the big criticisms of litigation, is that lawyers make a whole lot of money doing discovery in litigation, and arbitration is much more limited. And so that can be one of those cost factors that's a benefit to arbitration as well.
The distinction between the cost of litigation versus the cost of arbitration is significant, because to file in state court, it's about a $500 filing fee. It's a one-time fee, whereas to file in arbitration, it's going to be a significant amount more than that, in particular for the lengthy cases that require the arbitrators to spend a lot of time, where we're essentially hiring 1 or 3 lawyers to work up the file.
As we're talking about those costs, there's another significant factor, and this is sometimes in the contract and sometimes not, and that's attorney's fees to the prevailing party.
Right.
And so essentially what we deal with in that is we have what's called the American rule. And under the American rule, each party is responsible for paying its own attorney's fees, regardless of whether they win or lose, if there is no statement as to shifting the risk of those fees onto one or the other party. The British rule is that the prevailing party gets their attorney's fees. We don't have that here. However, the parties can agree to say that, if I have to sue you to get my money, then you're going to have to pay my attorney's fees. And so if I have a contract that says, Mr. Owner, if you fail to pay me and I have to sue you to get my fees, to get payment under my contract, and I have to hire a lawyer to do that, you're also going to have to pay my attorney's fees. Right. Now, if you have that provision and then the owner ends up suing the contractor, then what happens?
You're saying the flip side?
Yes. What happens when the owner then sues the contractor for bad work?
If it's a truly two-way provision, then whoever wins gets their fees. But there are ways to limit it, which I think you were referring to. If it's simply a provision that says, if I'm not paid and I have to go chase you down to collect my money, then I get my fees. Then, but the claim is, well, your work was bad, and therefore I'm going to sue you for how much I had to pay to fix your bad work. Well, we didn't have an attorney fee provision on that. So people do try that. They try to take any attorney fee provision and say, well, there's an attorney fee provision on this issue. That means if there's a dispute, then there's attorney fee shifting to whoever wins. Well, that's not what the Florida courts say. The Florida courts say if there's a specific subject matter it's contemplated for fee shifting, it only applies to that subject matter.
If it's worded well. But in construction contracts in particular, it's frequently my recommendation to contractors to not have an attorney's fee provision in the contract. For this reason, contractors have the benefit of Chapter 713, which is the lien law. Subcontractors have the same thing. It's a very powerful and a rare tool that contractors have the benefit of. And that is, if a contractor performs work that improves the real property and they don't get paid for that work, they can put a lien on the owner's property. The reason for that is they can't go and take back their labor. They can't go and unpaint the building, or they can't go and take the bricks off the building. Even though they think they can, they're not allowed to do that. And so for that reason, the courts in Florida, the legislature in Florida, and in many states, allow contractors and subcontractors to put a lien on the property, which means the owner cannot sell their property until they have satisfied that lien.
So you can go full on, if there's a dispute, the prevailing party gets fees. You could go halfway, and you could say, if I have to collect money, I get my fees if I win. Or you could simply rely on the lien law.
And not have anything in your contract.
Right.
Okay. So, Hugh, we've covered a lot of ground today. We've covered a lot of construction contract topics, many of which are very complex, and we've spent a lot of years fighting those, studying those, learning about those, and figuring out what works and what doesn't. Let us offer that service to you. If there's anything that we can do to help you negotiate your contract, figure out whether you've got a good contract or not, give us a call. We're happy to help. Thank you.